Are we ready to start the pro tem docket?
We are not. The defendant on for your docket for arraignment showed up in person. Dee is currently trying to get the computer in the council room set up so that she can appear.
Okay.
We also, Mr. Quintner, Robert Peterson showed up. I don't show him on the docket for today.
Right, I don't either.
Okay, so I will let him know he can go. I'll be right back. I thought so. Sorry, well, we haven't even started yet.
That's fine. I've always got stuff to do.
Okay.
I'll just be here waiting for, just let me know when we're on.
Okay, thank
I'll be
you.
here.
There she is.
So do you need me to do anything else, Lisa, or you did?
Nope, that's exactly what I needed. Thank you so much.
You're so welcome. Somebody be with you shortly.
All right, we are on the record. I'm Judge Pro Tem Chris Bates, and we have one arraignment, and that's City versus Malia Stewart. And is that you?
Yes.
Okay. So you are here today for your arraignment. You're cited with driving suspended third degree and a vehicle trip permit violation and a couple infractions. The two criminal charges you are cited with are misdemeanor offenses. They carry a maximum penalty of 90 days in jail and a $1,000 fine. You have rights in this court. You have a right to an attorney if you cannot afford one. You also have a right to hire your own attorney. You have a right to a speedy and timely trial before a judge or a jury. And if your case went to trial, you have the opportunity to hear and question the city's witnesses and have witnesses testify in your defense. If convicted at trial, you have a right to appeal a conviction. And so understanding the charges against you and your rights, how do you plead to the charges today? Guilty or not guilty?
Not guilty.
Okay. Do you plan to ask for a court-appointed attorney or hire your own?
No, Your Honor, I'm going to represent myself on this. And I'm going
Okay.
to be asked to waive my right to
Right to counsel?
the quick jury trial. I'm going to waive my right to that. I need some time for as late as possible. Like Raymond has me out until December, the last docket at the end of the year. In order to show medical evidence that I'm dealing with in the.
Okay, Ms. Stewart, I'm going to stop you right there. So if you plan to represent yourself, we'll need you to waive your right to counsel. And Madam Clerk, do we have that document? You're on mute. I can't catch any of that.
Sorry. I'm in another room than her right now, but I can get it to her on her way out.
Okay, yeah, if she can fill that out, we can set pretrial over, let's say, a month, and then I can review that document, decide if the right to counsel has been waived, and then Ms. Stewart, you can address the court a month from now regarding any potential continuances and the reason for those. Okay? So that concludes your arraignment today. The court clerk will mail notice of your next hearing to you, so make sure that we have a good mailing address for you.
Yes, sir.
Okay? So that concludes your case. Thank you for appearing today, and we'll see you next month.
Thank you.
All right,
The only other thing we have on for you, Your Honor, is Joseph Rogerson.
and he looks like he is in compliance.
Absolutely 100% in compliance.
All right, terrific. Well, I guess we'll keep doing bench reviews on that every few months or so. Oh, you're on mute again, Madam Clerk.
That's it for you.
Okay, terrific. Thank you.
I'm going to pause quick a minute, switch defendants around in the council room, and get Ms. Stewart her paperwork. Just a second.
During your lunch. Okay, thank you.
Okay, we have Miss Cohn. She is on for arraignment today. She is in the council room right now and on screen.
Is this for me or for Mr. Bates? For me? All right, Ms. Culp, can you hear me okay?
Yes, yes.
Great. Ms. Culp, you're here today for a first appearance or arraignment. My job today is I'm going to let you know what you're charged with, see if you want to have a public defender appointed to represent you, and to let you know what your rights are, okay?
Yeah.
Okay, so it looks like you are charged with, I'm sorry, is your name Cone?
Cone, C-O-N-E.
Right, you are charged with selling tobacco and alcohol to an underage individual. Under the Washington statutes, that is a gross misdemeanor. What that means is the maximum penalty is a $5,000 fine and 364 days in jail. Now, that does not mean that that's what you're likely to get in this case. I'm simply telling you what the maximums are, okay?
Oh, yes, sir.
Okay, I have read the police reports in this case, and I have found that there's probable cause. What that means is that there's enough evidence asserted in the report for the case to move forward. However, it does not mean that the court has found you guilty. You have the right to an attorney to represent you in this case at all proceedings. You have the right to remain silent throughout the proceedings. You have that right to remain silent even at trial, and that cannot be used against you. You can hire your own attorney, or if you can't afford one, a public defender will be appointed for you. Excuse me. You have the right to a speedy trial, which means for you 90 days from today. You have the right to have your guilt decided by a jury. The jury would begin the process by presuming you innocent and would have to find that you were guilty beyond a reasonable doubt in order to convict you. You have the right to testify at trial, but you're not obligated to do so. They can't use that against you. If you are found guilty at trial, you can appeal that question of guilt to the next higher court. At trial, you have the right to call witnesses on your behalf, and if you need to get witnesses into the court, they can be made to appear at no expense to you. You have the right to confront those witnesses as well. If you were to plead guilty or otherwise resolve the case without a trial, you would have limited rights to appeal. At this point, would you like the court to consider appointing you an attorney?
Yes, Your Honor, please.
Okay, and would you like to enter a plea of not guilty at this time?
Yes, sir.
Okay. What is your monthly income, ma'am?
I'm low income right now. I'm part-time at the inn. I make roughly $800 every 2 weeks.
Okay, I'm going to find that you do qualify for public defender, and I'm going to appoint John Whitner to represent you.
Thank
You will get his contact information, and you'll need to speak to him. He's here on the Zoom call. You can see him there at the bottom of the Hollywood Squares. And you'll get his number and give him a call before the next court hearing, which will be
September 22nd.
September what?
22nd.
September 22nd. So you'll be here at the same time on the Zoom, same process, September 22nd. So Mr. Whitner, can you give her your number real quick?
Of course. You have a pen?
Ms. Cohn, do you have a pen?
And I don't.
She's in the
you'll get it.
council
Oh,
room.
that's fine. Well, you're going to get it in the mail anyway, so it's not a big deal.
Okay.
So at this point, I'm going to direct that you come back for a pre-trial on September 22nd in this court, same time. Any other questions for this court?
No, thank you very much.
Okay, thank you, Ms. Cohn.
Yes, have a great day.
That is it for people who showed up in person.
Okay.
So I am gonna run out.
Would it be possible to focus on the pre-trials? I had a matter added at 1:30 from the dependency court this morning. So-
Sure.
Sure, absolutely.
I also have attorney Robert Alt on for the show cause hearing. However, whatever order you want me to, I will.
Mr. Duncanson, are you saying you need to get done as quickly as possible?
Pretty much, yeah.
I've got to be out of here by 1:30 as well.
Okay, well, let's just hit those pre-trials real quick and then move on to Mr. Alt's case.
Okay,
So, let's see, I've got Isaiah Bailey.
okay, I'm bringing him in.
Hello?
Hi, Mr. Bailey. This is Will Penoyer. I'm the judge for the city of South Bend.
Hi there.
We've got you on today for a pretrial. I received prior to court a stipulated order of continuance in this case and an order of dismissal. It looks like they'd be dismissing the speeding infraction and there would be a stipulated order of continuance as to the minor in possession charge. Is that accurate, gentlemen?
That's right.
Yeah,
Okay. So this, Mr. Bailey, you've reviewed this with your attorney?
Yeah.
Okay. And you understand that this is a contract basically between you and the prosecuting attorney. It's, I'm not the ultimate decider on this. This is something that an agreement you enter into with him.
yes, sir.
Okay. So your understanding is, looks like this is going to be a 6-month SOC. And what that means is that if you were to pay the fine, which is $150, and have no further criminal violations of law over the next 6 months, at the end, this case would be dismissed. Is that your understanding, Mr. Bailey?
Yes, sir.
Okay, and do you know, Mr. Bailey, what happens if you fail any of those conditions?
I'll be found guilty of the charges.
So what specifically will happen is the court would be at that point just reviewing the police reports to see if there was enough information there. Basically you'd stipulate to the admissibility of them and the facts within them. And most likely I would find you guilty.
All right.
So just one more time, just for safety here, make sure you understand what do you have to do to get this dismissed?
Just have just stay innocent of anything for 6 months.
Okay, that's about as simple as it gets. Do either prosecution or defense want to put anything else on the record on this?
No, Your Honor.
Okay, I will sign both orders. And Mr. Bailey, you'll get the information in the mail on how to make payments. Thank you very much.
Yeah, thank you.
Okay, so.
All right,
I have
so.
Three
Mr.
people in the
Bailey,
waiting room that I cannot identify.
all right. Mr. Bailey, you can log off. You're done.
Okay, thank you.
Thanks. So why don't we pull in whoever that is?
I'm gonna pull in the first one and see who it is.
Okay.
Hello, can you hear me?
Yes, I hear you.
What is your name?
Caleb Ayers.
Caleb Aris, okay,
That's an arraignment.
it is.
Yes.
Okay, Mr. Aris, I have a couple other cases to go through first. We will get back to you shortly.
Okay.
Thank you. Any others unidentified?
Two more.
Okay. Okay. Sir, can you you need to unmute yourself. There you go.
Hello?
Hi, is your name Marquise Law?
Yes, sir.
Great. We couldn't tell from the thing who is who waiting on the phone. Mr. Law, we have you on for a pretrial today. My name's Will Penoyer. We're in South Bend Municipal Court. And we have you on for pretrial. Your attorney, Jonathan Quittner, is here. The prosecutor's here. Mr. Quittner, what's going on in this case?
Well, I haven't heard from Mr. Law. I don't know, Mr. Law, if you've tried to contact me. I'm sorry if you have, but I've made no communications with him. So I'm going to ask that we set this one out. I think we have plenty of speedy trial time, and try to make some contact between us.
Mr. Law, do you have the phone number for Mr. Quittner?
No, sir.
Okay. Well, let's give that. Do you have a pen?
Yeah.
Okay. Maybe we should confirm his address too? I mean, because I assume the court sent him the phone number.
Yeah, and he,
He got notice of this hearing. So.
yeah, he would have received the hearing notice.
Mr. Law, are you there?
Yeah. Do you need my address?
Well, no, did you got the notice of this hearing in the mail from the court, right?
Yes, sir.
Great. So Mr. Quittner's number is 360-642-3139.
Yeah.
Okay.
Did you get that, Mr. Law?
Yes.
Great. So you'll need to call him before the next court date. I just want to make sure we don't have any speedy trial issues. When was Mr. Law arraigned? I thought it was 2 dockets ago, if I remember right.
8/11.
8/11. Okay. So if we come back September 22nd, that should be plenty of time. So Mr. Law, you'll need to call Mr. Quittner, and you're going to come back to court on September 22nd at the same time, same process.
Okay.
Okay. So do that, and hopefully this will be ready to go on September 22nd. Thanks very much, Mr. Law. And unless Mr. Quittner, anything else, are we done for today?
No, that's fine. I'll talk to you soon.
Okay. Thank you, Mr. Law. Just give him a call. Okay.
All right. Thank you.
Thanks. Bye. Okay. And one more, right?
One more.
Unidentified, I mean.
Okay. And apparently we lost them.
Oh, that's too
So
bad.
we have Mr. Mike Davis. We want to keep moving?
Well, Mr. Davis is a pretrial, right?
Yes.
Okay, well, pretrials are what we're prioritizing, so yes, please.
We
I
keep
think that's the only
moving.
other pretrial I have, actually. That's Mr. Aris.
I know. They keep moving them on my list.
Oh. Mr. Aris, we're trying to get a different person. We clicked on you inadvertently.
That's okay.
Don't worry, you will get. Such a strange mode of communication.
It is.
It also looks like Jamie got moved out of the room.
Kicking people out left and right.
She might have done it on purpose.
Hardly blame
It
her.
was probably when I was trying to click on removing Mr. Aris, I probably clicked on her because they keep moving them. Or they listed in.
All right. Mr. Davis, you need to unmute yourself.
Unmute. Can you hear?
I can hear a garbled noise, Mr. Davis. Are you there? Mr. Davis? Mr. Davis? Well, I can now see you, Mr. Davis.
Hello?
Okay, Mr. Davis. Mr. Davis, can you hear me?
Yes, sir.
Okay, Mr. Davis, my name's Will Penoyer. I'm the judge for South Bend Municipal Court. Did you hear all
Yes,
that?
sir.
Okay, and we're on for pretrial today in your case. And I'm going to ask your attorney what's going on with your case, all right? Hello?
Dang, I couldn't hear nothing of that.
Mr. Davis, can you hear me? Okay, I think, Mr. Davis, why don't you, we're going to have to try this again. This isn't working right now. So, boy. You guys have to be on at 1:30, right?
Me?
You and Mr. Duncanson are both have something at 1:30.
Yeah, and I should probably, oh, did we lose Mr. Davis? He's back.
Are you guys are your hearings on Zoom?
No, I have to go to Aberdeen.
Huh?
I have to go to Aberdeen. I'm supposed to be there by 3.
Oh, you have to leave. I got it.
Yeah.
Okay.
No,
I just don't want to make you guys sit around too much.
no, I appreciate it. The court should know, we're planning to dismiss the charge against Mr. Davis, and it doesn't require any action of him, although of course we do want to know that he understands what's happening.
Okay, have you talked to
I do
Mr. Davis?
understand.
Have you talked to Mr. Davis about it, Mr. John?
Yes.
Rather, Mr. Quittner. Mr. Davis?
Yes, sir.
Can you hear me okay?
Yes, sir.
Great. Mr. Duncanson, I understand that this case is going to be dismissed. Is that accurate?
Yes, he was licensed up in Alaska, so.
Okay, so you're just going to send, one of you is going to send me an order of dismissal?
Oh, I'm sorry. I thought we had taken care of that. Yes, I'll forward that to Mr. Duncanson. I don't know what this means for the infraction. We had not worked out anything with regard to the infraction. The criminal charge is being dismissed.
Mr. Duncanson?
It was my understanding from Mr. Quittner that his client actually tried paying the ticket like a while ago, so.
He requested a deferral. He technically holds a Class B learner's permit, commercial driver's license in Washington. I'm trying to confirm with the Department of Licensing right now what exactly the status of that license is. It is not listed as surrendered currently,
Okay.
which makes him ineligible for the deferral. So as soon as I get confirmation from them what the status of his learner's permit is on the commercial driver's license, then I can proceed with contacting him about what needs to happen with the infraction.
All right. Mr. Duncanson, do you have anything you wanted to add to that?
I'll make it easy on Madam Clerk and we'll just amend it to a seatbelt at the face value of the ticket if Mr. Davis is okay with that.
Mr. Davis, did you hear that?
Say it one more time.
So what he's saying is we're going to dismiss your criminal case. And if you were agreeing, and on the ticket, the speeding ticket, they would amend it to a seatbelt violation so it doesn't affect your driving record. And you just pay the, if you paid the ticket amount, then they would just amend it to a seatbelt violation. Is that all right with you?
Sounds good.
Okay, in that case, I am going to dismiss your criminal case when it's presented to me. And I will amend the infraction to a violation of the seatbelt rules, and I will find that it is committed and impose the fine, which I assume is what, 136, 139?
139, which he has
Okay.
already sent a check in for.
Oh, okay. So you already have the check. So, Mr. Davis, that's basically the long and short of it.
Okay.
You have any questions?
No, sir.
Okay, great. Well, thank you very much, Mr. Davis, and you have a great day.
All right, you too as well.
Okay,
I believe that's it for me.
that is it for pre-trials.
Okay.
All right, Mr. Duncanson and Mr. Whitner, it sounds like you guys are off the hook now.
Okay, thank you very much. Enjoy the rest of the day. Yes.
Unless Mr. Duncanson wants to participate in this show cause hearing for Mr. Tonkin.
I don't believe it's necessary. I guess the city's position would just be that if he's in treatment, just hasn't sent it, then. get it sent.
No, we received a notice from the treatment saying he's not compliant.
Okay, well, let's get.
I'll
can we
stick
just-
around because I have a few.
We'll just get this, let's just get it done. We'll do it quick.
All right.
All right. Will Penoyer, judge on the record. Mr. Alt, can you hear me?
I can, thank you, Your Honor.
And Mr. Tonkin, can you hear me?
Yes, Your Honor.
Great. So this is on for a show cause on a NIG driving case. It looks like there's an issue with compliance with treatment. My understanding is the court received information showing that Mr. Tonkin is non-compliant with the treatment at this time. So I don't know if Mr. Tonkin wants to have this set for a hearing, if he wants to admit, or what the parties would like to do.
Thank you, Your Honor. At this time, I believe Mr. Tonkin would admit that he is non-compliant with treatment and provide the court with an explanation. But
Okay.
no, we do not believe that, we're not requesting a hearing to contest the allegation.
Okay.
As for an explanation, and I can let Sean speak for himself to an extent, but Mr. Tonkin was initially at New Life Recovery after having been in inpatient treatment. Subsequently had, I guess for his own reasons, had some issues at New Life, and on his own began treatment at Hotel California by the Sea, which is a treatment agency located here in King County. Pursuant to some other work issues, etc., he is no longer at Hotel California by the Sea. I just learned of this hearing actually yesterday. Mr. Tonkin called me and informed me of this, and since then, already in the process of setting up, a new evaluation to get into treatment, having looked at the previous evaluations, obviously. Sean, without question, has not complied with what was in that initial recommendation with New Life Recovery. And we are asking that the court permit him the opportunity to obviously re-enroll with the strong understanding that he just needs to get it done. He needs to comply with it.
Okay.
Thank you.
Okay, well, my position at this point is I certainly would like to see Mr. Tonkin in treatment. And so what I think I'll do is set this out for 2 months for review on status. So then that would be, let's say,
November 10th,
November 10th.
correct.
So why don't we come back November 10th and see where Mr. Tonkin is, and if he has not made any significant progress into getting back into, the treatment as recommended. As I understand it, he completed inpatient, so this is a question of finishing the outpatient, right?
That is correct, Your Honor.
Okay, so I can caution Mr. Tonkin now that if he's not enrolled in something in 2 months, I appreciate that we're going through the coronavirus right now, that sort of thing. If he's not enrolled, there better be a good explanation, or I'm likely just to impose terms and move on from there.
Absolutely, Your Honor.
So I hope that gives him, Mr. Tonkin, enough incentive to get this done, and we'll give him an opportunity, though.
I appreciate that, Your Honor.
Okay. Thank you, Mr. Alt, Mr. Tonkin. So I'll see you both back here November 10th. And obviously, if you have documentation that you'd like the court to see, please provide it to the clerk.
Absolutely.
Great.
Thank you, Your Honor.
Thank you, Your Honor.
gentlemen. Have a good day.
Thank you, counsel.
Okay,
Okay.
Mr. Duncanson, I'll let you off the hook.
All right, thank you. Have a good rest of your day.
Thanks for your help. Appreciate it. Have a great day.
Bring Mr. Eris back in.
Great. Hello, Mr. Eris. For your patience. My name is Will Penoyer. I am the judge for the City of South Bend Municipal Court, and we are here today for a first appearance / arraignment for you. Mr. Eris, you are charged with failure to transfer title within 45 days. That
Yes.
is a standard misdemeanor, meaning the maximum penalty is 90 days in jail and a $1,000 fine. That's not what you're likely to get. You're not likely to get 90 days in jail for this or a $1,000 fine for this. That's simply the maximum that could be you could be sentenced to under the law.
Okay.
So I've reviewed the police reports and I find that there is probable cause for this case to move forward. What that means is that there's enough in the police report to support the underlying charge. Does not mean that I have found you guilty yet. You have the right to remain silent and you have the right to be presumed innocent until you are proven guilty beyond a reasonable doubt. You have a right to a jury trial, at which point you would still remain presumed innocent. You have the right to have an attorney represent you at all stages of the proceeding. If you cannot afford an attorney, one will be appointed for you by the court at no expense to you. You have the right to remain silent throughout this process, including at trial. And at trial, a jury would be instructed that that right to remain silent could not be used against you at the trial. You have the right to a trial within 90 days. Since you are out of custody, that'd be 90 days from today. You have the right to have your guilt decided by a jury. The jury trial, again, would begin with you presumed innocent, and you would have to be proven guilty beyond a reasonable doubt. You have the right to be present when evidence is presented at trial, and you have the right to question and challenge any witnesses brought against you. You have the right to have witnesses called to the court on your behalf at no expense to you. And you can call witnesses also to testify for you if you wish. You can testify if you choose. If you don't want to, that's also okay, because you have the right to remain silent. That can't be used against you. If you're found guilty at trial, your rights to appeal are quite limited. However, if you do go to trial and lose, you have the right to appeal that to the next level, which would be the superior court in the case of this municipal court. At this time, do you want to see about having an attorney appointed for you, Mr. Eris?
Yeah, I think that'd probably be best.
Okay.
I don't really know a whole lot about law.
So my suggestion to you, if you don't know, is I would recommend, assuming you qualify financially, we would enter a plea of not guilty today and appoint you an attorney.
Okay.
So would you like to do that?
Yes.
Okay, Mr. Eris, I have to inquire, what is your monthly income?
Let me think. Off the top of my head, I'd probably say net around 16 to 1800 a month.
Okay, and do you support anyone besides yourself?
I pay child support monthly.
How much?
I pay what is it? 100 and
100 and something.
it's 136, I believe, every 2 weeks.
Okay, all right. Well, Mr. Eris, I'm going to find that you do qualify, so I'm going to appoint an attorney for you.
Okay.
That will be John Quitner, our court public defender. You'll get his contact information in the mail. And we will set you on for a pretrial on September 22nd, same time as today.
Okay.
And you will contact your attorney between now and then and talk to him about the case. See if there's anything that can be done. And do you have any questions for me?
No, nothing I can think of.
Okay. Well, Mr. Eris, in that case, I've entered a plea of not guilty for you, appointed an attorney, and we will see you back on September 22nd.
All right. Thank you.
Thank you very much.
Okay, the only one left is our contested James Garvin. Unfortunately, the address he gave, he listed as the response address he wanted, has no mail receptacle.
Hmm.
So previous address is somewhere in California. We received that, not at that notice back, not at this address. So
Okay, so we don't have any way of contacting him?
short of driving out there and handing it to him personally,
Driving out where?
to the address he gave without a receptacle. It's a
Where's
fifth
that?
wheel on a piece of property.
Around here or what? Where is it?
Yeah, North Raymond.
Oh, okay. Well, that's frustrating that he's so close by. Boy. Well, I'd hate for him to miss an opportunity if he does wish to contest this ticket. I don't like anybody to waive their rights, obviously. And it sounds like he may have just misunderstood the process. I assume you don't have a phone number for him.
I do not. He did not list a phone number or an email.
Okay, well, then I guess the best we can do is bump this over to the next docket, the 22nd.
Okay.
And see if he makes an effort to contact the court and find out what's going on. I
Okay.
don't know what else to do.
All right.
Okay, is that all we got?
That's all we have.
Let me just look at my docket, make sure there's nothing that jumps out at me. No, okay. Well, thank you very much, Madam Clerk, as always. Appreciate it.
Thank you.
Are we gonna have the same login? Is there gonna be a standard login, or are you just gonna send us the Zoom login each docket?
Actually, I sent the entire rest of the year out in an email. I can resend it.
Does
Seems
the
like a
one-
lot of people missed it.
When did you send it?
Back in June.
Okay, I probably just overlooked it somehow. Could you just resend it to me?
Absolutely.
And I'll get on that. We already
Okay.
took care of those court rules, so I think we're pretty good right now.
We are all set.
Okay, thank you, Madam Clerk. Have a
Thank
great day.
you. You too.
Bye-bye.
Bye.